I welcome you in the 14th lecture regarding legal compliance for incorporating a startup, and I am in the module of incorporation of one person company, private limited and public limited company. And now I am specifically talk law relating to non-profit company. Now you might be wondering why I am discussing with you relating to law relating to the non-profit making company, or what is this particular company all about. Now, you might have an interest to develop your business or start your startup to address some of the social cause, or you might be interested to address might be interested to address some of the scientific innovation, or carry forward the research in a particular area. So, in these circumstances, it is advisable that you incorporate your startup as a non-profit company. And when we are talking about the non-profit company, it can be a private limited company or it can be a public limited company. But only thing which you get in case of a non-profit company is that you can drop the name of the limited, which I am going to discuss with you a little later. Now, if it is a private limited company or public limited company, it can have a similar kind of structuring, like it can be limited by share, or it can be limited by guarantee, or it can be unlimited. And you will find most of the provision, or all the provision relating to the non-profit company is provided under section 8 of Companies Act 2013. Now, previously in Companies Act 1956, non-profit company is provided in section 25. So, if you talk with many people, or commonly you will find people talk about the section 25 company. Section 25 company means they are basically non-profit company. But please remember, non-profit company do not mean that they cannot do the business or they cannot pay the salary to the worker. They can do all the function which is normally required for doing the business. But what is bar here is that to distribution of the profit, if you are making any profit, or you should not participate in the commercial venture to make the profit. So, in case of a non-profit company, you get some kind of a special grant from the company, from the government, and these particular non-profit company enjoy the different kind of exemption under the different law. So, it can be a tax exemption, it can be receiving the donation, and while you are receiving the donation, you might the people who are donating, they might also enjoy the tax exemption. They can also get kind of a concession for using the different infrastructure facility. You need to talk about the formation document, what are the matters to be incorporated in the formation document. And please do note, if it is a non-profit making organization, then in that case the formation document differs from the private limited company or a public limited company ordinarily. So, there is a special provision you need to incorporate into this memorandum or article of the association, and the participant memorandum and article of the association is provided as a schedule in the Companies Act itself. Then again, whenever you are going for this non-profit organization, you generally get a certificate of incorporation from the registrar. So, to be more specific relating to the objective of a non-profit making organization, it can be promoted for promotion of the commerce, arts, science, sports, education, research, social welfare, religion, charity, protection of the environment, and any such other objective. So, it is quite broad based, and for different purposes you can do. So, if your startup is fall with any of this particular objective and you wanted to address any of the cause, then in that case you can incorporate your company as a non-profit making organization or non-profit making company. Now, as I have told you that it intend to apply its profit or other income for promoting this particular objective. So, you do not distribute the profit which you are making in this particular company, but you wanted to use it for the purpose or the objective with which you have incorporated this particular company. And as I have told you that it is not encouraged to distribute the dividend to its member. Now, let me take you in the next issue. Now, these rules relating to, I mean, whenever you are going for a non-profit company, in addition to applying to the register of this particular company, any association of the person or any body or any number of people should apply to the register of the company while they are incorporating this particular company, and state it very clearly in that particular application that what is the purpose for which you want to incorporate this. Similarly, when you are drafting your objectives in the memorandum of association, you need to specify these particular objectives in the objective clause itself. Now, if you are doing some work which is not prescribed or not as per the condition which has been provided under this under this concession, then in that case you can you cannot continue continue using this particular I mean you cannot continue dropping this particular name of the limited word limited. But if you are fulfilling the condition, then in that case you can drop the word private limited as well as the limited from the name of this particular company. So, if you want to remove this particular thing, then in that case you need to drop this particular name. But please let me tell you that whatever the law which is applied, either in case of a private limited company or a public limited company, those laws do apply for non-profit making companies. So, if it is relating to filing of the return, if it is relating to administration management and administration of the company, if it is relating to the annual meeting and the procedure which need to be followed in the annual meeting, what are the matter need to be reported in the annual report, or whatever the matter need to be reported in a financial statement, or the appointment of the auditors, or if you wanted to issue the shares for acquisition of capital, whatever you want to do, in every time you have to follow whatever the standard condition has been prescribed for a particular form of the company, either it is a public limited company or it is a private limited company. And if it is a public limited company, then in that case you have to follow whatever has been prescribed for unlisted as well as listed company. Now, a company registered under these particular sections shall enjoy all the privilege and be subject to all obligation of a limited company. So, that means you enjoy all the privilege, but there is a limitation also. That means whatever law, that is what I was talking about, whatever law applies to all these particular companies also applies to you. Now, in case of this non-profit company, the firm can also be a member of this particular company. So, many of the time even you will find the company or number of companies promote a non-profit company, like a company which is a holding company and its subsidiary company can promote another non-profit company for doing the research which they are going to use in their business. So, maybe the R&D division of the company or a group companies can be promoted as a non-profit making organization. So, the moment we are using the word firm, it is basically having a wider connotation. So, it can be even the LLP, it can be even a registered partnership firm, it can be the society, it can be a cooperatives, it can be other private limited company or public limited company. They can all promote this non-profit organization in addition to an individual who can promote this particular organization. A company registered under this section shall not alter the provision of the memorandum or article except the provision of previous approval of the central government. So, as I have told you before that these kind of company having a specific structure prescribed in the Companies Act itself as a memorandum and article of the association. So, whenever you are filing the memorandum and article of association for non-profit making company, the government is going to scrutinize. Government means here the registrar of the company going to scrutinize that it is according to the non-profit making companies MOA and AOA, and he should get satisfied that. And then the subsequently in the general meeting, if you wanted to change the any of this particular provision which has been mentioned in the AOA and MOA, then in that case you need to have a prior permission from the government itself, otherwise you cannot do that. Now, a company which is registered under this said section may convert itself into any other kind after complying whatever the condition is required or may be prescribed. So, non-profit company which is a private limited company or non-profit company which is a public limited company can convert itself to a public limited company or a private limited company, or maybe they can convert it into a LLP or maybe any other business form. So, whatever they do, then they will be subject to that particular provision of the conversion, whatever has been prescribed under the different law for the conversion of that kind of organization. Now, let me come into the another aspect. Central government may at any point of time revoke the license which is granted to the company if it is found that the affair of the companies are conducted fraudulently or in the manner violative to the objectives of the company or prejudicial to the public interest or without prejudice to any action against the company under this particular act. Now, if you look into these particular three things, that is conducted fraudulently or violative the objectives of the company or prejudicial to the public interest, these are a very broad construction. Mainly when we are talking about prejudice to the public interest. So, what constitute a prejudice to the public interest is depending on a particular time, particular societal norms, or it might be the norms which are or good governance norm which has been prescribed for a particular segment or particular issues by the government from time to time, or it might be even against the interest of the general public. Like this particular company is a research company carrying on some kind of a experimentation on the animals, and because of that there is some kind of a local disturbance happening in the local community. So, it will go against the public interest. It might be relating to the matter of the health, because because of the activity of this particular company or the experimentation of the company, the local environment is getting affected. So, it will be against the public interest. Now, when we are talking about the fraudulent means you are basically making a profit, and then those people who are carrying forward this particular business, they are one or other way around rewarding themselves even though they are not distributing the profit, but they are trying to getting the benefit out of that. Let me give you some example, like possibly the chairman of the company did not get any money out of that, but he has purchased a private jet for him through the money of this particular research company, or maybe he has financing his vehicle or car by this particular company, and then he is possibly building the facilities by the money of this particular company, and which he is enjoying by his own. So, these are the follow through activity. Basically, you are on the face of it showing that it is a research organization or research company, but you are actually utilizing the proceeds of this particular company for your own benefit. Similarly, when we are talking about violative the objectives, that means you have possibly incorporated for a social cause or promoting the art, but you have actually involved in a business of antique art, and then you wanted to get certain exemption of these particular antique goods preservation, and then you are possibly exporting this particular antique stuff in the other country. So, it might be again the violation of the public policy which is prevalent at that time. So, if you are doing all this thing, then in that case you have been your license will be withdrawn as a non-profit company. Then the central government is to satisfied that it is essential in the public interest that the company registered under this section should be amalgamated. So, it might so happen that you have been given the license to operate as a non-profit company, but over the years your financial conditions or the operation mismanagement has gone in such a level that you are no more able to carry out as a good organization setup or good company, or it will be good if you are going to amalgamate it or merge with any existing company of the similar nature. Then central government can give the direction relating to that, and in that circumstances the company will be merged. So, there is every possibility of merging of this particular company with a similar objective, with the company of the similar objective, which are actually incorporated for non-profit making or non-profit making company. Now, there is a penal provision if there is a the contravention of any of this particular provision who are managing this particular company, then in that circumstances there can be a fine from 10 lakhs and it might be extend up to 1 crores of rupees, and the director and every officer of the company shall be punishable with imprisonment. So, this is a quite a stringent provision. So, if you are violating the grant which has been given to you, then in that case those people who are the office bearer or the members of the company will be subjected to the imprisonment. So, if you are if you think that well your startup is somewhere going to address some of the issues which you have discussed in the objectives of the company, and it is going to solve some of the social problem. So, instead, and you have a very less capital, you want to incorporate the startup for addressing the social need, then instead of incorporating your startup as a profit making company or profit making organization, you can even decide to incorporate your startup as a non-profit making company. Please do remember, when I have discussed with you relating to cooperatives, I said that cooperatives also having some kind of a social objectives if you wanted to incorporate. But these particular organization, non-profit companies, are more structured than that of a cooperatives, and as because they need to have they need to maintain a structured information relating to their finance, relating to their capital, relating to their business transaction. Many of the time it is easy for this particular company to raise the capital from different financial institutions. Even you can access the market also for raising the capital. But this particular flexibility you might not have in case of the cooperatives. Again, the cooperatives are governed by state laws. So, if you wanted to do the business beyond, or if you wanted to carry forward your transaction beyond the state boundary, there might be a difficulty. But if it is a non-profit company, then in that case you can carry forward your business, or you can carry your business in any part of the country or in any state. So, depending on your business objective, or depending on your objective of the startup, you might even choose between the cooperatives or non-profit company. Thank you.